case heard by video?
Yes.
Thank you. Ms. Kirkland, you've been charged in case 22 CR 007896G with criminal trespass. Is there a history, Mr. Howard? Good afternoon.
Hey, this is the third arrest. Got a 2011 family offense, domestic assault out of Birmingham. 2014 FTA for suspended license, not prosecuted.
Afternoon, Ms. Campbell. Is this your case?
Yes, Your Honor. Good afternoon. Ms. Kirkland is also a cross-defendant with another person on the calendar, and that person's name is Jeffrey McGee. So I did want to let Your Honor know that before I proceeded. I'm sorry, I didn't hear you.
I represent Mr. McGee, Your Honor.
Okay, good afternoon. You can continue, Ms. Campbell.
Yes, Your Honor. So as to Ms. Kirkland, the facts alleged are that on the date of November 20th, 2022, at approximately 10 a.m. at the location of 14002 Cypress Court, which is in Alpharetta, Ms. Kirkland was in a verbal dispute with the cross-defendant in this matter, Mr. Jeffrey McGee. Ms. Kirkland actually took Mr. McGee's cell phone and broke it. She indicates that she broke the cell phone because Mr. McGee flipped over her desk and broke her work computer. After that, Mr. McGee responded to Ms. Kirkland's action of breaking his cell phone by grabbing her, and he left visible scratch marks where he grabbed her at on her breast. So officers did respond to the location, which is the residence that both parties shared together, and they were both taken into custody. So those are the facts as to Ms. Kirkland. The state's recommendation for bond at this time is a $2,000 signature bond, as well as no further contact with the cross-defendant in this matter, Mr. Jeffrey McGee. And that is because, as pretrial mentioned, the only prior arrest in Georgia is a traffic-related arrest, so there's no prior history as far as the criminal history is concerned. So that's the state's recommendation, is a $2,000 surety bond and a stay away. I mean, a no contact order.
You mean signature on bond?
Yeah, sorry. Signature.
No objection, Your Honor.
Thank you, Ms. Kim. I need to work out the no further contact issue, though. Mr. Howard, does Mr. McGee have a history?
Yeah, he don't have any violence. Last arrest was 2020 for DUI out of Sandy Springs. He's wanted out of Sandy Springs on a probation, I guess, for the DUI. Got a 2017 probation out of Gwinnett, 2017 probation theft by taking, and a criminal damage to property arrest that was dismissed. 2016 probation, first offender for theft by taking in 2015, and a 2009 suspended license.
Okay. Thank you. Ms. Kim, what is the relationship between Ms. Kirkland and Mr. McGee? And for both Ms. Kim and Ms. McLeod, is there a request for contact?
No, my client is fine with a stay away and no further contact. They have been dating for 3 years and they lived together. However, they have no children, and my client is fine with no contact.
Okay, does she need to go back to the Cypress Court address to pick
Yes.
up any?
Your Honor, actually, that is in her name. She is the leaseholder, so I think he should get out of the place.
Your Honor, my client is also fine with no further contact.
Does he have a place to go, Ms. McLeod?
He says he can stay with his mom, Your Honor.
So for Ms. Kirkland, it's going to be a $2,000 signature bond through pretrial. No further contact with Mr. McGee, and no drugs, alcohol, or weapons while out on bond. Good luck to you, ma'am.
You can have
Thank you.
Courtroom,
Position 14G.
Okay, thank you.
we're looking over us.
Good afternoon, Mr. McGee. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. McGee, you've been charged in case 22 CR 007897G with battery, family violence, and cruelty to children. I've already gotten your history in the matter. Ms. Campbell, do you have anything to update regarding the facts of the case or your recommendation?
Yes, Your Honor. I would like to add to the facts that the reason why Mr. McGee was also charged with cruelty to children because there was a juvenile present in the home when he did commit the alleged battery against Miss Kentasha Kirkland. And with regard to the state's recommendation for bond for Mr. McGee, it is $4,000 surety bond, $3,000 surety bond on the battery, and a $1,000 surety bond on the cruelty to children. The state also recommends no contact with the other person involved, Miss Kentasha Kirkland, as well as a stay away from the residence.
All right, so for Mr. McGee, it's going to be for the battery, a $2,000 SO signature bond through the jail, $1,000 signature bond through the jail for the cruelty to children. It makes it for a total of a $3,000 signature bond through the jail. No further contact with Ms. Kirkland. Stay away from the Cypress Court address. He can go back to that address on one occasion with law enforcement to retrieve any belongings if he has any there, and no drugs, alcohol, weapons while out on bond. Is that satisfactory with you, Ms. McLeod?
It is, Your Honor.
Your Honor, can my client also get a signature bond through jail as well then? To be consistent?
Well, I'm sending Ms. Kirkland through pretrial because she was recommended. Mr. McGee has some other things that he needs to take care of. Apparently, I do want to see Ms. Kirkland through pretrial, so I'm going to leave it through pretrial for her, but not for Mr. McGee.
Thank
All
you.
right. Good
Yes,
luck to
Your
you.
Honor.
Thank you, Your Honor.
All right, quick question. On the cruelty to the child.
Hold on, Mr. McGee. Let me just say.
Mr. McGee, this is not trial. We don't have to discuss that.
Oh, all right.
You've already gotten your bond. The court has addressed that. When it's time for us to go to trial, we will handle the cruelty to children charge.
All right, thank you.
You're welcome.
Good luck to you, sir.
Position 3, Coleman.
Good afternoon, Mr. Coleman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 007883D with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
Second arrest. Last arrest was in May for battery, DV, cruelty in the 3rd. Appears to be open out of Cobb.
Ms. Backus, good afternoon.
Good afternoon, Your Honor. Following up on what Mr. Howard said, it is open. That case in Cobb is 22 M2382. They were unable to give me the bond at the time, but he is out, or she is out on bond. There's also a Florida cycle from 2020. And that is an aggravated battery to a pregnant woman. And this incident happened 2 days ago on the 19th. An officer responded to a call from Crabapple Road in Lacoma Trace about a domestic call. Upon arrival, the victim, Mr. Joshua Vandervoort, ran towards the officer, advising him that his child's mother, who's the defendant, had attacked him by striking him and scratching him in his face, causing scratch marks. Mr. Vandervoort said that prior to the officer's arrival, he and the defendant were traveling down the road, arguing about him helping her with her DoorDash route, but not receiving any money from it, and said that she then attacked him again by scratching his face. He held his hand up to defend himself, and that's how he got cut on his knuckle when she struck him with her hand. He also said that their children were present during the incident. They were in the back seat. Officers did observe the visible injuries on him, and he said that it appeared to be fingernail marks on both sides of his face, as well as the cut to the knuckle. The defendant advised the officer that they had gotten into an argument over his crazy driving. She was attempting to kick him out of the vehicle when he took the key from her. And that's when she said she called the police to de-escalate the situation. However, the officer did not see any visible injuries on her. And they did say that they had one child together, and that they lived together at 345 Hawkins Street Southeast in Marietta. The state is requesting a $3,000 cash bond. That May 2022 incident, that battery, family violence, and cruelty, same victim. And that's just a few months ago, already out on bond. And so in addition to the Florida case, so we are requesting a cash bond instead of surety, no further contact with Joshua Vandervoort, a one-time police escort, and a third-party transfer of the child, and no alcohol, drugs, or weapons while out on bond. Nothing further.
Have your office spoken with Mr. Vanderhoort?
I do not believe so, Your Honor. We attempted, but we're not able to reach him.
Good afternoon, Ms. Camp.
Good afternoon, Your Honor. Ms. Brianna Coleman is 26 years old. She has been in the Atlanta, Georgia area for 2 years. She does not have any family members here. They are all in Florida. However, she does have custody of her 3 children, ages 7, 3, and 1. She is the primary caretaker, and she is not receiving any child support. She informed me that she, in fact, shares 2 children with Mr. Vandervoort, the 3-year-old and the 1-year-old. Ms. Coleman graduated from high school. She also has a bachelor's degree in business administration. However, she is only marginally employed as a DoorDash worker, where she only works about 10 to 15 hours per week. The rest of her time she devotes to caring for her children. She also states that she is currently enrolled online and studying IT and childhood development. She strongly denies the allegation. She states that they were, in fact, in a car ride. She had been driving all day. She was very tired. She was basically trying to she had asked Mr. Vandervoort to get out of the car. She states that he pulled the e-brake, he snatched her keys and grabbed her glasses all off of her face while she was driving. She states that she is the person who in fact called the police, and that he has this history of just trying to do whatever he can to get her in trouble. And she states that he also has a vested interest in making up these false allegations because he's trying to obtain custody of the 2 children that they share. She finally states that there is footage that would tell a different story of what actually happened between these 2, but she states that the police did not want to hear her side of the story. Now, regarding my client's history, we did hear about an incident back in 2020. However, I did not hear a disposition for that. There is no disposition for the case in May of 2022, which involves Mr. Vandervoort. She states that, again, he basically made up these allegations against her with no convictions for violence, Your Honor, and her situation as primary caretaker and also her limited income, Your Honor. I am asking for a signature bond on Ms. Coleman's behalf. And if Your Honor determines that she is ineligible for it, I would ask for a more reasonable bond, Your Honor, a bond of no more than $1,000. And that would be $750 for battery, family violence, and $250 for cruelty to children in a third. My client does not want to continue having contact with Mr. Vandervoort. She has to find another place to live. So therefore, we are unopposed to the no further contact order. We are unopposed to the one-time law enforcement escort. However, she does want him to be able to continue to see his children. So again, we're unopposed to the third-party transfer. Thank you, Your Honor.
All right.
Mr. Howard, did you have something to say before I?
Yeah, I'm sorry. Yeah, I missed that Florida one, but Judge, the Florida was ag battery. It was reduced to battery, and it was a conviction. So my bad on that.
Okay, you're fine, Mr. Howard. Thank you.
And that's what I was going to say, Your Honor. I would also just like to say that if she has a continuing issue with her child's father, and he continues to do things to try to get the kids taken from her, I just find it awkward that he would be helping her with a DoorDash route. Yeah, based on that conviction and the open, again, Your Honor, we are asking for that cash bond, nothing further.
Your Honor, Ms. Coleman has the right to parent her children and do whatever she needs to do to take care of them. State's contention regarding Mr. Vanderwoord's what he's willing to do, he's not even here, Your Honor, it's speculation. I would just ask that you focus on what's before you, Your Honor, and give Ms. Coleman a reasonable bond so that she can get out of jail and continue caring for her children.
Okay, so for the battery family violence, it's going to be a $1,500 good bond. For the cruelty, it's going to be a $500 good bond, making for a total of a $2,000 good bond. No further contact with Mr. Vanderhoort. Stay away from the Hawking Street address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she might have there. She can have third-party transfer for visitation with the minor children, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Ms. Coleman.
Thank you, Your Honor.
Thank you, Your Honor.
Position 13, McCoy.
Good afternoon, Mr. McCoy. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. McCoy, you've been charged in case 22 CR 0078889A with battery family violence. It's my understanding that this is Mr. McCoy's first arrest from pretrial. Let's see. Good afternoon, Ms. King.
How you doing?
I'm doing well. Thank you, Ms. King. I hope you are as well.
Thank you,
Good
sir.
afternoon, Judge. I represent Mr. McCoy, Tom Nagel.
Good afternoon, Mr. Nagel.
Good afternoon.
This offense occurred on November 19th of this year. Officers were dispatched to 2910 Ivy Ridge Lane in Johns Creek. They were dispatched to a domestic dispute between father and son. The defendant is the son. Upon arrival, they met with the defendant and they also met with the victim, who stated that they had been in an argument about the defendant taking a weekend off from work. And when his father advised him that he would not be allowed to go to work, he became angry and attempted to leave the residence. At that point, the father followed him outside and told him he could not leave. And that's the point where the defendant shoved his father to the ground. When the officers arrived, they noted seeing injuries to the left hand and elbow of the father. That's a result of him getting pushed to the concrete. We have been in contact with the victim in this case, and he stated that he does not want to press charges, and that now he is saying that he does not believe the defendant pushed him and that he may have tripped and fell. The defendant is 17 and in high school. For that reason, the state is consenting to a 5,000 signature bond through pretrial services, but we are asking for a curfew from 9 p.m. to 6 a.m. We're asking for no further violent contact with Benjamin McCoy, his father, a one-day anger awareness, and no drugs, alcohol, or weapons while out on bond.
Mr. Nagel.
Your Honor, my client's 17 years old. He's a senior at Centennial High School. He's a straight A student, no prior criminal history. He works nearly full-time at Fighter Group restaurant. So we're asking that Your Honor consider a $1,500 good bond or a UJR in the case. My client, his father is on the Zoom call here, and Judge, he said he doesn't know how he fell. He is a multiple amputee, and he's his only parent, but he didn't tell the police that he pushed him. He wasn't sure how he fell down, but that's what we're asking the court to consider.
Okay. The solicitor is recommending a signature bond, so I'm going to grant him a signature bond. It's going to be a $2,000 signature bond through pretrial, one-day anger awareness. Mr. Nagel, is Benjamin McCoy, your client's going to need a co-signer. Is Mr. McCoy willing to co-sign to get him to release him?
Mr. McCoy?
Yeah, I can put it up. That's not a problem. And I should clarify one thing, Tom, Your Honor. I'm not sure. Like I said, I'm a triple amputee from diabetes. I don't know for a fact. I cannot speculate whether he pushed me, whether I lost my balance. We
That's-
just
yeah,
tore
that's-
down our lens. Yeah, I just don't know.
That's an issue for,
Okay, I just wanted to make sure that I was very clear. I'm sorry.
Absolutely.
I'm not the most
So-
astute computer person.
All right, Mr.
So
McCoy.
yes, I can do whatever.
Okay, it's my understanding that you want your son back in the household. Is that correct?
100%.
It's my understanding. It's my
This is
understanding
my
that,
good kid.
and you're not afraid of him.
Absolutely not.
And he's in school, and it's my understanding that he's doing well in school.
He's doing very well in school, and he works every Wednesday night and every Friday and Saturday, and he gets home about 2 a.m. I mean, the kid busts his butt. So I'm not going to make excuses for him because I really don't know what happened. But I do know that we were having a debacle because he wanted to see his girlfriend. If you want to know the honest to God truth, he won't tell me that, but I know that's what it was. They work at the same place together. So I don't know the ins and outs. He's being a teenager. He's being a 17-year-old boy, but I'm not concerned about him at all. I have 2 kids adopted from Guatemala, and he's my good kid. This one's the one that if he's supposed to be at work at 2 o'clock, he's there 10 minutes early, so he doesn't inconvenience someone. So I rest assured I'm not concerned at all.
Okay, so let me just say, Mr. McCoy, you're not going to have to put anything up for him because he's going to get a signature bond. But what you are going to have to do is you're going to have to sign for him as a co-signer since he's only 17 years old.
Sure.
Are you going to be able to do that? And when you go pick him up, you're going to need to bring a utility bill regarding where you're living. Okay.
I can do that. I can pull that up online. Do I need a hard copy or just a computer copy?
You should get a hard copy just in case.
Okay. I'll take care of that.
All right, so he's to have no further violent contact with you, and he's also, well, he shouldn't be anyway, but he's to have no drugs, alcohol, or weapons while he's out on bond, okay?
Yeah, there is a weapon in the house, but I can remove that if that's necessary.
Okay. Anything further for Mr. McCoy, Ryan McCoy?
Your Honor, I just like to ask, you said you were asking for a curfew, is that correct?
She was asking for a curfew. Given what I've heard about Ryan McCoy, about how well he's doing in school and about how hard he's working, I'm not going to require a curfew on a first arrest, given given what I've been told about him.
Thank you, Judge.
Thank you.
Okay. All right. Good luck to you.
Attorney Nagel, you can stay on. I'm gonna send you the address where the dad can come and co-sign it.
Okay, will do. Thank you.
I'm gonna put it in the chat for you.
Okay, thank you.
Tony, will you be back in contact with me then?
I'll be in touch with you. You're free to go.
I can disconnect. Thank you.
Yes.
Have a
Thank
great
you.
day. Okay, goodbye.
You have a good rest of the day. Who do we have next?
Rob.
Thank you, Judge.
You're welcome. Who do we have?
Sorry, Judge. This is going to be position 12, Langford. I didn't realize I was muted.
Oh, you're fine, thank you. Good afternoon, Mr. Langford. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. You have been charged in case 22 CR 0078888J with loitering and prowling and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
That's his first arrest. He need a co-signer too. He only 17.
Ms. King,
What?
Oh, I'm sorry.
is this your case?
It is. I thought I heard somebody. This offense occurred on November 20th at around midnight. The defendant was at 701 Atlanta Student Movement Boulevard in Atlanta, and he was seen going through the parking deck, looking into vehicles and pulling on door handles. Once law enforcement was called and arrived on scene, the defendant decided to flee on foot and disobey loud verbal commands to stop. He was ultimately apprehended. The state is recommending a 3,000 signature bond through pretrial. We are asking for a curfew from 9 p.m. to 6 a.m. due to the charges and the defendant's age. We're asking for a stay away from the incident location and no drugs, alcohol, or weapons while out on bond.
What was the breakdown, Ms. King?
Oh, my apologies, Your Honor. That is 2,000 for the loitering and 1,000 for obstruction.
Okay, thank you.
Your Honor, no objection. We do have a mother, I believe she may be at the courts. If not, she could be here at the Zoom hearing because I spoke with her.
What's his mother's name?
Actually, his father was gonna be the co-signer. It is Milchcah. Last name is Mccray.
Say that again?
Okay, first name is Milchcah.
CAH.
Yes. Last name is Mccray.
And have you spoken with Mr. McCray?
Not Mr. McCray, but I spoke with a mother who spoke with him, and also I spoke with his big brother, who is older than 25 years old. And yeah, everybody
Okay.
was willing to co-sign, but I only needed one person. So
All right, so Mr. McCray is going to co-sign. You have to inform him that he's going to need a utility bill
Valid ID.
or valid ID. And so it's going to be a $2,000 signature bond through pretrial for the loitering and prowling, and $1,000 signature bond through pretrial for the willful obstruction, making for a total of a $3,000 signature bond through pretrial. Stay away from the Atlanta Student Movement 701 address, and no drugs, alcohol, or weapons while out on bond. And Ms. Kim, you're going to need to inform someone that they'll need to co-sign for him and what they're going to need to bring. Okay.
yes,
Has judge made a decision regarding the curfew, Your Honor, 9 p.m. to 6 a.m. This offense did occur at midnight. The state feels that the curfew will be beneficial to the defendant.
Ms. Kim, Mr.
Your
Langford,
Honor. Only thing is though, he plays basketball for his high school, Washington High School. He wants to be a professional basketball player. So I don't know how long he has to practice. So that part, I would like to say maybe curfew at 11 p.m., Your Honor.
9 a.m. to 11 p.m.
6
9
a.m.
p.m. to 6 a.m., Your Honor, was the state's request.
All right, I'm gonna, given that he is doing after-school recreation, I am gonna give him from 11 p.m. to 6 a.m.
Thank you, Your Honor.
All right, good luck to you, Mr. Langford.
Yes, sir.
Position 15, Shagarabi.
Good afternoon, Your Honor. Diane Claire for Mr. Shagarabi.
Good afternoon, Attorney Claire. Let's see, it's my understanding that there might be some issues in this case that we may need a breakout room for. Is that that was the request from Ms. Campbell? Do you
Yes,
understand?
Your Honor.
Okay, you have any objection to that, Ms. Claire?
Well, I didn't know that there would be any issues that we need to speak about, but I'm open to speaking to Ms. Campbell.
Okay, so why don't we go into a breakout room quickly so that we can discuss those issues. So Ms. Campbell, Ms. Claire, Ms. Falk, good afternoon, Ms. Falk. Anyone else need to be in that breakout room?
Yes,
Yeah,
his father, Mr. Hamid Shagarabi, is on the call as well. So he will-
Okay, and so the father also.
May I also please be in
Oh,
that?
yes,
as well?
yes, Ms. Kim, yes.
I'm gonna go check on that breakout.
Okay, thank you, Ms. Bridgewater. Good afternoon. Okay. Good afternoon, Mr. Shagarabi. I'm Judge Eric Mora. We have had the opportunity to discuss your case with your counsel and with the solicitor's office. It's going to be a $2,000 signature bond through the jail, no further violent contact with your father, no drugs, alcohol, or weapons while out on bond, but you're to stay on all of the prescription medication that you're currently on, okay? All right. Good luck to you, sir. All right. Anything further, Miss Claire? Do you have any other cases with me today?
No, Your Honor, I'm asking.
Yes. Have a good afternoon. Thank you. Who do we have next?
Mr. Taylor.
Okay. This is position number 16, I believe. Good afternoon, Mr. Taylor. I'm Judge Eric Mora. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
How you doing? Yes, Your Honor.
Fine, Mr. Taylor. Thank you for asking. You have been charged in case 22 CR 007890E with criminal trespass. Is there a history, Mr. Howard?
22 total. Last arrest was November 10th. Failure to appear for shoplifting, not done with it. He has 2 open shopliftings, 1 open trespass. On probation for trespass out of state court, 22 CR 004714F. That was as of August 4th. On probation for trespass, 22 CR 007141E. That was as of November 8th. On probation for another criminal trespass. They got a lot of trespass.
Are any the open shoplifting and trespass, are those in Fulton?
Yes, they are, Your Honor. Let me see, one, 2, 3, 4, 5 of them, no, 6 of 8. 8 of them are in, since 2018, are in Fulton County.
Okay, and how many of them are currently open, Ms. King?
I do not show any open. I only see the shoplifting open. When you look on case manager, you actually see them concluded. One is late as last month.
And I'm sorry, the open, you see 1 open shoplifting?
That is correct. I believe that's the one he was referencing.
Okay, and is that the one that's open in another jurisdiction, or is that open here?
That is another jurisdiction.
Okay, all right, thank you. Go ahead, Ms. King.
And Your Honor, the defendant actually pled guilty to criminal trespass in August, same incident location. The others were at Lenox Mall, and then we have 2 more that are at Grady, Your Honor. And on November 20th, the defendant was at Emory University Hospital Midtown. He was actually sleeping in the location. He was not there seeking medical attention and has multiple criminal trespass citations on file, especially due to him being on probation for it from August, shows that he has no regard for the court's orders. So for that reason, the state is asking for a surety bond in this case, a 500 surety. We're asking from him to stay away from the Emory University Hospital Midtown at 550 West Peachtree Street Northwest, and no drugs, alcohol, or weapons while out on bond.
Okay, thank you, Ms. King. Ms. Kim, is Mr. Taylor residentially challenged?
No, Your Honor. Yeah, actually, he does have a address, 340 Glen Street, Southwest, 30312. Indeed, I am actually still sending out social worker services to check his behavioral health evaluation done. So that way, if we have to verify if he needs any further assistance. So he has been here in Georgia for 2 years, and he says that he works at a bar doing washes dishes, cleaning up the trashes, and he does not make a lot of money. So he's qualified for public defender's service. So we would like to be, we have to work with him. I don't think he has any financial resources to pay for any bond. So we would like to request for a signature on bond. Thank you.
Ms. Bridgewater, when is the reset for the SAP calendar?
It is December the 13th.
Okay. So I'm going to take the state's recommendation at this time, Ms. Kim, of $500 good bond. Stay away from the Emory University Hospital unless he has a reason to be there. No drugs, alcohol, weapons while out on bond. You've represented to the council that to the court that he is going to have a social worker visit. If you would make sure that if he doesn't get out on bond, that on December 13th, they report to me regarding whatever their findings are, okay?
Yes. Yes, Your Honor.
And if I didn't say it, no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Taylor.
Judge, repeat that bond amount.
It's a $500 good bond.
Thank you.
Position 17, Ward. Have a seat.
Good afternoon, Mr. Ward. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Ward, you've been charged in case 22 CR 007891C with battery. Is there a history, Mr. Howard?
The 7th arrest. Last arrest was in March. Criminal trespass, damage to property, terrorist threats, and simple assault. He's on probation for simple assault as of March. 22 CR 001297C. Also on probation for criminal trespass and damage to property. 22 CR 001299C. Got a probation violation, 2017 criminal trespass, 2016 shoplifting dismissed, 2016 burglary. It says transferred to state court, 2015 unlawful for a person to associate with criminal street gang that was not presented to the grand jury. He had a 2015 burglary. There was amended to trespass conviction. That's it.
Yes, Your Honor, this offense occurred on November 19th. Officers were dispatched to 2798 Peak Road Northwest, apartment 218. They were dispatched to a woman being beaten by a male. Upon arrival, they met with the defendant in this case who stepped out of the location and he had blood on his hands, face, feet, and head. He stated that he and his family had gotten into a balloon fight that got out of control. At that point, the officers told him why they were there, and he said that the victim was Margelia Bell, Margueaila, last name traditional spelling, and she came outside. And they began to speak with her, and she stated that she was beaten on by the defendant. She stated that it started when she wouldn't clean the bathroom. So he began to punch and push her. And he pushed her into a table and he punched her into the wall. And then her sister was actually present and took video of the incident. She showed the video to law enforcement. He recorded on his body cam. And in the video, he did see the defendant hitting on her in the video, and she was yelling for him to stop, and he continued to do so. At that point, the officers put him in custody. Due to the defendant being on probation for a violent offense from just this March, Your Honor, the state is asking for a $5,000 surety in this case. We are concerned for the safety of Ms. Bell as well as the citizens of Fulton County. That was a different victim and a different incident location in that conviction. We're asking for no further contact with Ms. Bell. At this time, it appears that the location is where he resides, not her. So the state is not asking for a stay away, but of course the state will defer to Your Honor if you feel that would be best. And no drugs, alcohol, or weapons while out on bond.
Mr. McLeod?
Yes, Your Honor. My client is 26 years old. He denies that he was the primary aggressor in this incident. In fact, he tells me that the alleged victim pulled a knife on him and that he was defending himself against her. He also tells me that he had to be taken to Grady Hospital, where he received 5 stitches behind his ear. As the prosecution said, when the police got there, he had blood on him. That is because he actually was attacked by the alleged victim, who happens to be out on bond for an incident where she pulled a knife on someone else and actually stabbed them. So he contends that he was absolutely not the primary aggressor and that she had brought someone else there also, who apparently another woman that she's been in a relationship with. And that was the reason why all of this happened. And he was actually the victim here, Your Honor. I understand that my client does have some history. He is working, Your Honor, but he's not in a position to pay bond, certainly not any significant bond. As the prosecutor said, it is his residence. She does not live there, Your Honor. So I would ask the court to consider giving him, if not a signature bond, and certainly a bond of no more than $1,000 so he can get out and get back to work, because he is employed, Your Honor, and he's okay with the no further contact with the alleged victim. Thank you, Your Honor.
Your Honor, I would just like to note for the court that the officer noted in his report that in the video, he saw the victim in a defensive position, and the defendant being the aggressor, even with her yelling for him to stop. She was the victim in this case, and he was the primary aggressor, which is why he was the only one arrested, Your Honor.
Thank you. It's going to be a $1,500 good bond, no further contact with Ms. Bell, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Ward.
Thank you, Your Honor.
4, Cruz.
Good afternoon, Mr. Cruz. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon, yes.
Thank you. Mr. Cruz, you've been charged in case 22 CR 007899Y with battery family violence. Is there a history, Mr. Howard?
Judge, I don't have that file. My coworker has it because he's on both calendars.
Okay. Ms. Backus, do you have his history?
Yes, Your Honor. He has 20 cycles in Georgia. Most notably, he's got one, he has an open case up in Superior Court 22 CP 214124. That one is felony fleeing, criminal attempt to commit a misdemeanor, obstruction, felony marijuana, possession of a controlled or Schedule 1 controlled substance. He also has a 2021 simple battery, family violence, and obstruction. That's 21 CR 006094Y. That is open out on a $6,000 surety bond, same victim. He also has a 2020 battery, family violence, which is 20 CR 004560Y out on a $20,000 surety bond, same victim. Prior to that, he's got obstruction, 2018 obstruction, possession of drug, tampering with evidence, simple battery, criminal trespass in 2018, FTAs, driving while suspended, and then it goes back a little further.
So what you're telling me, Ms. Backus, is that he has already 2 open cases with the same victim as the victim in this case that he's out on bond for, is that right?
That's correct, Your Honor.
Okay.
That's correct. So this incident happened back on March 17th. An officer responded to 3146 Reeves Circle Northwest, Unit 151, on a call from the victim, Ebony Baines. Ebony is spelled EBONI. She stated that her children's father, the defendant, had stopped by and knocked on the door. He does not live at the location. He stays with his mother, but the officer found out that APD has created several reports, obviously, and arrested him. He said at least once in the past year, from what he had found, for either attacking her or vandalizing her car. The officer noted that these events usually start with him coming to the apartment to see the kids and becoming angry when he's asked not to stay. Despite making numerous calls, he did note that Ms. Baines continues to invite him there to bring resources for their children. So on the date of incident, he brought over shampoo and conditioner that she had requested via text. She didn't invite him in, but when she opened the door, he pushed his way inside. They began fighting when she tried to push him out of the apartment. He mushed her in her face, causing her to go down. She fell on her knees, skinning it to the point where the officer noted it was bleeding. And then he squirted shampoo all over her front door and all over her car. the officer did document the injuries on the body worn camera. And she stated that she did want to press charges. We were not able to reach her today. But there was also, Your Honor, a 2017 DV protective order with the same victim. So that was 2017 CV 297891. And so, Your Honor, based on that history, the state is requesting an $8,000 cash bond. No further contact with Ebony Baines. Stay away from that brief circle location, a third-party transfer of the children, one-time police escort. If he's still there, which he shouldn't be, but if he's still there, one-time police escort to get his belongings, and no alcohol, drugs, or weapons.
Thank you. Ms. McLeod?
Yes, Your Honor. My client is 31 years old. He is the father of 3 children. They range in age 5, 3, and 1. He shares these children with the alleged victim. They are no longer in a relationship, Your Honor. He tells me that it's been a consistent pattern with her of making up allegations against him and calling law enforcement on him. And that is the primary reason why they are no longer in a relationship and they do not live together. He does not need a one-time law enforcement escort or any such thing because they do not live together. He just wants to be able to see his children, Your Honor. He denies this allegation that he went there and tried to start something. He says it's just something that his ex does. You know, she's constantly trying to bring drama to situations and to make allegations against him which are untrue. I acknowledge that my client does have some history, Your Honor, but he is really not in a position to pay any significant bond, and a cash bond would be absolutely no bond for him. He does have to support these 3 children, and he has to support himself as well. And these are just allegations, Your Honor. So I would ask the court to take that into consideration in giving him a bond, and that it be a reasonable surety bond, Your Honor, and not a cash bond. Nothing further.
Anything further, Ms. Backus?
I mean, again, Your Honor, I would just like to re-highlight the open cases on top of the fact that I doubt, I mean, I wasn't there, but I don't think she dragged her own knees across the ground to scrape them. The officer, again, did document the body worn camera with her injuries. So nothing further.
Okay, it's going to be a $15,000 surety bond. Stay away from the Bree Circle address. No further contact with Ms. Baines. He can have third-party transfer of the children for visitation, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr.
Thank you. Your Honor, my business before the court today is concluded. May I be excused?
Yes, Ms. McLeod, you have a good afternoon.
Thank you, Judge. Same to you.
Thank you.
Position 10, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jones, you've been charged in case 22 CR 007895F with battery family violence. Is there a history, Mr. Howard?
Only Jones I have is Antonio. Ronald Jones was not on my pool sheet.
Ms. Campbell, do you have his history?
Yes, Your Honor.
Okay, thank you.
You're welcome. So the facts as alleged for this defendant are that on the date of November 20th, 2022, at the location of 3255 Harris Drive, which is in College Park, this defendant is alleged to have punched the mother of his child. Her name is Viola Goodman. He also lives with her with a closed fist. Basically, he punched her with a closed fist, and the officer arrived and did observe bruising.
My kids stay in Ohio.
Oh, Mr. Jones, let me just tell you that You have a right to remain silent. Anything you say can be used against you. We have an attorney representing you here today, and we don't interrupt people. I'll give you the opportunity to speak in turn, but in this court, if you have something to say, you're going to have to wait until you're called upon. Okay? So if you want to speak with your lawyer, or if you want to say something to the court,
Well, this is the wrong case.
wait. You will be given the opportunity, but you will not be given the opportunity to interrupt anyone in this court. You understand me? I apologize, Ms. Campbell. Continue.
I apologize. Is this Ronald Jones or Antonio Jones?
This is Antonio Jones. He was
Okay, my
trying to say
apologies.
that-
I was speaking of Ronald Jones, so I apologize, Your Honor.
I got first arrest for Antonio.
So we all started out with Ronald Jones, that was called as position number 10. So are we going to have a Ronald Jones this afternoon?
Yes, there's also a Ronald Jones in the calendar.
Your Honor, we did not have Ronald Jones in our pull sheets this morning, so none of us has interviewed Ronald Jones.
That is correct, Judge. And on our pull sheet, we have Antonio Jones and also on the calendar as well.
Okay, yes, but I was
There's
told.
something wrong with Odyssey because I pulled 3 different ones and it had different names on the pull sheets.
So let me start this again then. You know, if somebody knows that I don't have the right person and someone should, you let me know that right away. First of all, let me apologize to you, Mr. Antonio Jones. I apologize. You were just trying to make this right. So the court apologizes to you. Let's go. This is case number 22 CR 0078884C with Mr. Antonio Jones for battery family violence. Which solicitor is going to present?
Judge, let me say this too, though. Number 7, Anthony Ingram, he wasn't on my pull sheet, and I don't have his file either when we get to it, just so you know.
All right, so let me just do one thing at a time. Who's presenting?
Your Honor, if you could just give me a moment, I can present this since no one is volunteering at this point. Let me just take just one moment, please. And just so I make sure we have the right person, we are referring to Antonio Jones, not Ronald Jones. Is that correct?
That's my understanding.
Okay.
My apologies, Deputy Falk. I have Antonio Jones as position 9. That's my case. Is that what we're trying to get to?
That is correct.
Okay.
I was just going to go ahead and handle it myself rather than try to figure out who's.
My apologies.
I
I
will let you continue.
Okay. My apologies, Your Honor.
Yeah, go ahead.
Again, Antonio Jones, first arrest. This incident happened on the 19th. An officer responded to a call at 303 Summit Place Drive in reference to domestic violence incident. Upon arrival, the officer spoke with the victim, Celeste Jones, and she stated that her husband, who's the defendant, had just assaulted her and left the scene. She informed the officer that her and her husband have had several altercations in the past. Prior to this incident, prior to the officer's arrival, the couple had returned home after eating dinner. When they got to the house, the defendant said he was going to the liquor store. However, due to some previous issues in their relationship, Ms. Jones followed him and she tried to contact him several times. When she reached him, she told him that she did not believe that he was going to the liquor store. So she went home and waited for him. When he arrived, they began to argue, and she told him to sleep on the couch for the night. He got mad at her, picked up her laptop, threw it at the television, in the bedroom, and then he pulled her by her hair, dragged her toward the sink in the bathroom, at which time he slammed her head against the sink and struck her in the mouth, causing a visible laceration to her tongue. Ms. Jones then accidentally called her mother, and her mother could hear the commotion, and that's when she told her mother to call 911 because he had assaulted her. Your Honor, the state is asking for a $3,000 surety bond, no further contact with Celeste Jones, to stay away from that incident location. I would assume there would need to be a one-time police escort, 1-day anger awareness, and no alcohol, drugs, or weapons. Nothing.
Has your office spoken to Ms. Jones?
Yes. I mean, not Miss Jones, Your Honor, sorry. I apologize.
No, Your Honor, I don't believe so. I believe we attempted to contact her and have not been able to do so.
Thank you. Go ahead, Ms. Kim.
Yes, Mr. Antonio Jones is 37 years old. He is Georgia native, and he has 2 children outside of this marriage. They have been married for the last 1 year. They live together, and the house is actually marital property. However, my client is not opposed to stay away nor no further contact. They do not have any child together, and he has his parents and siblings here in Georgia, so he can go and stay there. He's working as an inventory specialist, and he's not qualified for public defender's service. So after today's bond hearing, our office will not be representing him, and yet he does not have any other histories. So we would like to request for a signature on bond for him. Thanks.
All right, it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further contact, this time with Ms. Jones. Stay away from the Summit Place address. If he needs to go back to that address, he can go back on one occasion with law enforcement to retrieve any belongings, and no drugs, alcohol, or weapons while out on bond. Good luck to you, sir.
All right.
Your Honor, if I may.
Yes.
Both Anthony Ingram and Ronald Jones appeared to have been add-ons to the jail calendar. As Ms. Glover stated, there seems to have been some irregularities in the jail pull sheets. I have verified that both Mr. Anthony Ingram and Mr. Ronald Jones are currently in custody on misdemeanor charges without bond. So they are at no bond status. So they need to be heard because currently they are just sitting in jail on no current set bond, which, as you know, on misdemeanors, they are entitled to some sort of bond and a first appearance hearing. In particular, Mr. Anthony Ingram, he was booked in on November 18th. So today is his 3rd day.
So are we going to be...
Yeah, Ms. Kim, is it possible that you can interview Ms.
Yes.
Okay, I'm gonna send him to the phone now, and then I'll do.
Thank you. Thank you.
Thank you so much, Jail. I really appreciate that.
Okay,
Ms.
so, hey, Ms. Kim, Judge, he doesn't want, he wants to go pro se.
Okay.
He want to be interviewed.
What about Ronald Jones?
Ronald Jones, we're still we're trying to find him.
Okay. Thank you.
All right. So this is position 7, Mr. Ingram, is that right?
Position 8. No, okay, yeah, let's switch that. This is gonna be Mr. Ingram. Mask up for me, Ingram.
Okay, and is Mr. Ingram the one who wants to go pro se?
Yes, Judge, that's correct.
All right, thank you. Good afternoon, Mr. Ingram. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay. Mr. Ingram, let me just say, you have a right to remain silent. Anything you say can be used against you. You have the right to have an attorney present at this proceedings. We are providing you, if you would like to be represented by a public defender today. It's my understanding that you don't want to be represented. Is that correct?
I just did all this with another public defender in another room. I thought she handled all the charges.
He was in felony court. He
She
just
said
came
all
from
the
felony
charges.
court, Judge.
Oh, okay. So, Mr. Ingram, you're charged here in case 22 CR 00789 with simple battery family violence. I'm happy to let you speak. So that was not handled in your previous court appearance today. Would you like to speak with the public defender about this charge?
They threw one of them charges, my family violence charge out.
Okay. Well, this is another one, sir. This one occurred on February 24th. So this one is still pending here. So if you want to talk to somebody this afternoon, a lawyer.
I want to get over it now because I have 4 more charges. Only she, the judge over there in the felony court just threw out one.
Okay, Mr. Ingram.
I got 2. I'm trying to figure out how I got 2. How do I have 2 family violence and she just threw out one for the same date of arrest, February?
Well, I don't know. We're here on the bond for that, Mr. Ingram. If you want to have someone, a lawyer, help you with this today, I'm happy to give you that opportunity.
Will it get settled today? I'm trying to get out of jail today.
Well, we're going to have a bond hearing today. So yes, someone will talk with you right now.
Okay.
If you'd like to talk to them about it, okay?
Go ahead and have a seat over there.
All right, thank you.
You can
So-
talk, Kim. And I'll just do my.
Okay. And Your Honor, just to offer some clarification to the court and whoever else may be listening. He had February 24th, 2022 charges for simple battery family violence against Patrice Ingram, as well as charges stemming from May 14th of 2022, which involved robbery by sudden snatching, family violence, battery, and cruelty to children in the 3rd degree, also against Miss Ingram. So there are 2 separate cases, all for which he was arrested in November. And then 3 of those charges, the robbery, the battery, and the cruelty to children, went to felony first appearance. The simple battery, because it was an unrelated date, came to us.
So Ms. Kim, if you would like to talk to him and explain that to him, and we will wait for your report, okay?
Thank
Ms.
you.
Kim, you have the number?
I do have a number to the jail, so I'll call.
Okay. And this is going to be position 8, Jackson.
Good afternoon, Mr. Jackson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Jackson, you've been charged in case 22 CR 007892Y with battery family violence, 2 counts, and 1 count of criminal trespass. Is there a history, Mr. Howard?
3rd arrest. Last was 2014, simple battery theft by taking. It was non-pros. 2009, fleeing an officer.
Okay. Ms. King?
Yes, Your Honor. This offense occurred on January 13th of this year. Officers were dispatched to 419 Lucky Street Northwest, 200 Parker Street Northwest, and 200 Mill Street Northwest. Upon arrival, they spoke with the victim of this case, Latara Rice, Latara, last name traditional spelling. And she stated that she went to pick up the father of her child, who was a defendant at the State Farm Arena. When they got there, she immediately noticed that he had been drinking all day. He works at the State Farm Arena, so that means that he had even been drinking while he was on the clock. At that point, he got inside of the SUV that she was in, and they started to argue. The victim caught him talking to another female on the phone yesterday, which triggered the fight the day in question. They were parked in the rear of the parking lot. And during the argument, the defendant got so irate that he got out of the vehicle and physically pulled their 4-year-old daughter, Zuri Jackson, out of the vehicle, causing her to get scratches on her left and right arms, as well as on her thigh. These injuries were captured on body-worn camera and visibly seen by the officers. At that point, the child was laying on the ground, and the defendant jumped into the driver's seat of the vehicle. The victim, Latara, jumped in the backseat of the vehicle to prevent him from leaving in her vehicle. The defendant started to drive around the neighborhood, and they were fighting inside of the car. Ultimately, the defendant stopped and started to beat her in the backseat of the car in her face, head, and arms, causing visible injuries that the officers observed and captured on their body-worn camera. Eventually, they were separated, and the defendant picked up several large rocks and broke out every window of that vehicle, Your Honor. And in the process of throwing one of the rocks, he actually struck Miss Latara in her back as she was running away from him. The defendant then fled away in the vehicle and ultimately left it somewhere else. We have been in contact with this victim. She states they are in a relationship and they live together at 509 Lucky Street, and they do share the child that is a victim in this case. She states that things have been good since this incident and there have not been any incidents since. She says that he was drinking at the time of the incident and needs help with his drinking. The victim also states that she's currently on dialysis and the defendant helps her with her child. This ultimately concerns the state. There seems to be a dependency here that will cause the victim to tolerate things that she should not tolerate to her and her child. Furthermore, Your Honor, the defendant was arrested 3 days ago, it appears, and he has made 18 calls to her from the jail since then. The state is concerned with victim intimidation, and especially with the victim highlighting how she needs the defendant in this case. Due to the graphic facts of this case and the state's concerns between the victim and the defendant, the state is asking for a $7,000 surety. That's $3,000 for each battery family violence and $1,000 for the criminal trespass. We're asking for no further contact over the objection of the victim in this case, and we're asking for no drugs, alcohol, or weapons. We're also asking for no further contact with both victims, Zuri Jackson, Z-U-R-I, last name same as the defendant, and Miss Rice.
Ms. Gant.
Thank you, Your Honor. Mr. Jamarius Jackson is 31 years old. He has been in the Atlanta, Georgia area his entire life. He has family here, including his mother and his 4 children. He shares a 4-year-old with the complaining witness, Ms. Latara Rice, and he also has 3 additional children, ages 8, 6, and 11. He states that he is paying child support for his children. Mr. Jackson completed 11th grade. He is still employed at State Farm Arena and has been so for 2 years. He strongly denies the allegations. He certainly denies drinking at his job, including striking anyone. He states that there was not a child that was present in that car. Your Honor, I did not hear about any convictions for Mr. Jackson for violence, Your Honor. Therefore, I'm requesting a signature bond. We do not believe that the state has set forth a sufficient basis for my client's intimidation of this complaining witness. It is her wish to have contact as it is my client. There has not been any prior instances between this couple, and they are presumed innocent. This incident is alleged to have occurred back in January. They have continued on as a family. Again, I am requesting a signature bond on Mr. Jackson's behalf. We are requesting no violent contact, Your Honor. And if Your Honor determines that he's ineligible for a signature bond, then I would ask for a reasonable bond, no more than $1,250, $500 for each battery count, and $250 for the criminal trespass, Your Honor. Thank you.
Your Honor, if I may, there was an independent person at the scene, a brother of the victim. That's who the child was left with when the defendant took the victim on a joyride. That's where the child was, Your Honor, and the officer observed this child, spoke with this child, as well as the independent witness that the child was there and the child was injured in this altercation. Furthermore, Your Honor, I just want to highlight 18 calls in 3 days, Your Honor. That is excessive for anyone. I don't even talk to my husband that much, Your Honor. The state is concerned and the state is requesting a surety bond in this matter.
How, Your Honor, if I may, how often counsel speaks with her husband is irrelevant. Apparently, this couple have a relationship. They rely upon each other. We should not resort to anything that the state is saying about what's reasonable or not in terms of their communication. We do not have any evidence whatsoever of what their communications levels were prior to this incident. And lastly, this is a bond hearing. It's not about guilt or innocence, Your Honor. Thank you.
And is this Miss Latira Rice, the alleged victim, on the line with us?
I did see her, Your Honor, earlier on the line.
I think she's trying to unmute herself, so if she wants to address the court, I'm happy to give her that opportunity.
Yes, sir. This is me.
Okay, can you raise your right hand, Ms. Rice? The other one? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Nothing really. Yes, we do have contact. Yes, we do stay together. And it's not like I'm dependent on him or anything. It's just at this time, this is just what's working for us. Now, I did say that I do think that he should try to get some alcohol
Objection, Your
treatment or
Honor.
something like that. But other than
Objection.
that,
Please stop
then
interrupting my victim. Thank you.
This court to tell me what she needs to tell me. Go ahead, Ms. Rice.
oh, well, I did say that he probably do needs to get some, alcohol treatment. But other than that, then everything else is fine.
Afraid of him?
So, what you say, sir?
I said, are you afraid of him?
No, sir.
And since this offense date, has this happened again?
No, sir.
Do you want him to stay in the household?
Yes, sir.
And the minor child that we're talking about, is that your child with Mr. Jackson?
Yes, sir.
And is he how responsible is he with your child?
He takes her back and forth to school. They go places together. Everything is nothing done wrong by her.
Okay. Thank you, Ms. Rice. I appreciate it. Counsel, anything further?
Nothing further, Your Honor.
Nothing from the state.
All right, so these are going to be signature bonds through pretrial, $2,000 signature bond through pretrial for the first battery charge, a $2,000 signature bond through pretrial for the second battery charge, a $1,000 signature bond through pretrial for the criminal trespass, making for a total of a $5,000 signature bond through pretrial. No further violent contact with Ms. Rice. And I'm gonna, since he's going through pretrial, have him have random drug and alcohol screenings and no drug, alcohol, or weapons while out on bond. So, Mr. Jackson, I'm gonna let you out, but you're gonna have to make sure that you return when your next hearing date. Guys, I'll put a warrant out for you, okay? All right, good luck to you, sir.
Thank you, Your Honor.
Position 7, Ingram. Get your mask up for me.
One child. I had one child.
So, Ms. Kim,
Oh, I forgot. I'm sorry, Judge, I forgot. He's also, Ms. Kim is also interviewing Mr. Ronald Jones. So you're gonna have to sit back over there. You have to sit back over there. Position 6, Eccles.
good afternoon, Mr. Eccles. I'm Judge Eric Morrow. This is the State Court Expedited Accusations calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Eccles, you've been charged in case 22 CR 007893D with driving under the influence of alcohol, less safe, improper erratic lane change, and possession of an open alcohol container. Is there a history, Mr. Howard?
11 total. Last arrest was in May for battery DV out of Gwinnett. 2021 suspended license. 2021 ag assault strangulation battery DV. 2008 fugitive from justice warrant out of Missouri. Last arrest in Missouri was in 2006. I didn't see any DUIs, whatnot.
Jackie?
Yes, Your Honor. This incident occurred yesterday. An officer observed a vehicle fail to maintain its lane on Old Alabama Road. Saw this twice. The defendant drove over the center line with his left tires, and then, well, he failed to maintain lane, Your Honor. He went over the line several times, and so the officer then initiated a traffic stop, identified the driver. The officer noticed that his eyes were bloodshot, watery, and it said that there was an odor of alcoholic beverage coming from the vehicle. The officer asked the defendant if he would agree to perform the standard field sobriety test, to which he agreed. And in doing so, he showed numerous clues of impairment. During these tests, the officer could tell that the odor was coming directly from his breath and would get stronger as he was close in proximity. The officer placed the defendant in custody, and he did not take other state tests. The officer did search the vehicle at that time because of the incident or the nature of the incident. He did find a 12-ounce can of White Claw. He also found a water bottle that had a clear liquid in it. And when it says that they did the field alka sensor, and it showed that it was positive for alcohol. So it was some sort of clear liquid. He doesn't have any other DUIs, Your Honor, but he is currently out on a bond, supposed to be staying out of trouble. And so driving under the influence while dangerous is also a violation of bond. He is out on that 2021 ag assault, strangulation, and battery family violence that's open. That's 21 CP 200860, and that's a $10,500 straight bond. He also has that. He's also out on bond, I believe in Cobb County for this one, for the May 2022 battery family violence. But they did say that even though he's out on bond, it is unaccused, yet they're in the investigation process, Your Honor. And so because of the current being out on bond, not supposed to violate any further Georgia law, supposed to stay out of trouble, the state is asking for a $4,000 surety bond. That is $3,000 on the DUI, $500 on the remaining 2 counts. No driving if he's not supposed to be driving, and no alcohol, drugs, or weapons. Nothing further, Your Honor.
Thank you, Your Honor. Mr. Vernon Eccles is presumed innocent, and he strongly denies the allegations, Your Honor. He's 53 years old. He has been in the Atlanta, Georgia area since 2006. He does have family here, including his 4 children, ages 17, 15, 10, and 5. He is the primary care taker for his children. He is not receiving any child support. Mr. Eccles completed high school. He also has certifications in HVAC and carpentry. He is currently employed as a supervisor for a construction company. He has been in this job for over 20 years, Your Honor. Again, he strongly denies the allegations, and it's irrelevant regarding my client's being out on bond for violent offenses. This is a driving offense. We see that he had an issue with his license back in 2021. That is resolved. There is no charge before this court. I'm requesting a signature bond on Mr. Eccles' behalf. If Your Honor determines that he's ineligible, and I would ask for a bond of no more than $1,500. That would be $1,000 for the DUI and $250 for the remaining counts. And we are opposed to any restrictions on his driving that have not been put in place by driver services, Your Honor. Thank you.
Your Honor, just quickly, I would have to disagree with Wanda or PD Gant, my apologies, in the vein that her saying that it's just because it's a violent offense, him being out on bond is not related. He should not be violating any further Georgia law while out on bond. And he's done that by driving under the influence and having an open container in the vehicle. And so the state disagrees with that position and finds it very relevant. Nothing further.
Okay, for the DUI, it's going to be a $1,500 good bond. For the erratic or improper lanes change, a $250 good bond. For the open container, $250 good bond. Makes for a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Eccles.
Thank you, Your Honor.
I'm sorry, Judge, I'm just walking back. What was his bond?
$1,500 for the DUI, $250 for each of the other charges, so a total of $2,000 good bond.
Thank you.
Okay.
This is gonna be position 7, Ingram.
So is Ms. Kim back with us?
Yes, Your Honor.
Okay, you ready, Ms. Kim?
Yes.
All right, so I've already done the preliminaries with Mr. Ingram. Is Ms. Campbell?
Yes, Your Honor. The facts as alleged for Mr. Ingram are that on the date of February 24th, 2022, this defendant became angry and aggressive with his wife, the victim in this matter, Ms. Patrice Ingram. Basically, she refused to spend tax money on things that he wanted. And so he got upset and he pushed her out of their garage and she fell to the ground and she hit her knees. At that time, he also took her keys from her and locked her out of the home. The state also wants to bring to the court's attention the defendant's history. He does have a prior 2013 conviction for battery, family violence, and cruelty to children out of Clayton County. And more recently, he has a 2022 arrest actually in November of this year. So I think that was the felony case that was being discussed earlier pertaining to this defendant, where there was a battery family violence charge involving this same victim. And so those are the relevant prior cases. There's also a 2010 conviction for simple battery. And there is a few other convictions for things like possession with intent to distribute and sale of marijuana. The state does believe that based on the prior history, that this defendant is a risk of reoffending and that this defendant is also a danger to the victim, his wife in this matter. So the state's recommendation for bond is a $5,000 surety bond. The state also recommends that the defendant have no further contact with the victim in this matter, Ms. Patrice Ingram, as well as the defendant be instructed to stay away from the residence and that he be instructed to complete anger management.
Do you have the residential address?
Court's brief indulgence.
Okay. While you get that, Ms. Kim?
Yes, Your Honor. Mr. Ingram is 48 years old and he has been here in Georgia for the last 20 years. And he and Ms. Patrice have been married more than 25 years. And Your Honor, of course, they live together and as it is marital property. And they also have a child, 3 of them together who are all minors. His address is 100 Fruitwood Trace. And my client says that he does have a job at upholstery and he has been working there for about 7 years. He also has a GED. And since he is the head of the household who pays for 3 children, all are minors, and his wife who does not work, he is indeed qualified for public defender's service. So his income source is very limited and he's not making enough money. Your Honor, this happened prior to those 3 felony charges that he already went to the court and got the bonds or not. This happened on February 24, 2022. Prior to those 3 charges, Your Honor, we would like, this is a very remote case. We would like to request for a signature bond on this case. Thank you.
Ms. Campbell?
Yes, Your Honor. My odyssey is going really slow, but I would like to just give a brief rebuttal. The state doesn't believe that this is a remote case. As the state mentioned, there is a prior conviction from 2013 out of Clayton County for battery family violence. And as Ms. Kim just stated, this victim and this defendant have been married for 25 years. So it's the state's belief and the state's contention that the same victim was involved in that case. And so it's also, there was also a cruelty to children, a conviction there as well. And so the state's concern is that we have at least, 3 different incidents where this defendant has violently attacked his wife, and the state does not believe that it's remote. And the state does believe that this defendant poses a danger to this victim. And so that would be the state's rebuttal. And I did finally get to pull up the address. One moment. So I have that the address that they have together would be 3255 Harris Drive. Is that correct? I'm sorry.
That is for Jones, Ronald.
You're right. I'm apologizing.
It's okay, no problem.
I've been having problems with Odyssey, but hold on.
I was showing a 100 Fruitwood Trace.
That's what I have as well.
Okay, thank you.
No problem.
All right, so it's gonna be a $2,000 good bond, no further contact with Patrice Ingram. Stay away from the Fruitwood address. He can go back there on one occasion with law enforcement to retrieve any belongings that he might have there. Third-party transfer of any minor children, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Good luck to you, Mr. Ingram.
Position 10, Jones. You have a seat.
Good afternoon, Mr. Jones. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 007895F with battery family violence. Is there a history? Is this one that you did not pull, Mr. Howard?
Wasn't on the push.
Okay. Do you have the
I
history?
have the history. Yes, Your Honor. I have that this defendant has most recently a 2011 conviction for simple battery family violence involving this same victim in this matter. I also have that he has a 2008 arrest for aggravated assault and cruelty to children involving this same victim. That was dead docketed. I also have a 2005 conviction for aggravated assault against a law enforcement officer. And then we have a 1991 and a 2000 conviction for simple battery. I would note that in total, he has 30 cycles, but those are the relevant portions of his criminal history. And the facts as alleged for this defendant are that on the date of November 20th, 2022, at the location of 3255 Harris Drive in College Park, this defendant is alleged to have punched the mother of his son. Her name is Viola Goodman, and that's spelled Viola. He also lives with Viola, and he punched her with a closed fist in her face. When the officer arrived, the officer did observe bruising above her eye, consistent with her being punched by this defendant. The defendant's son, who also was at the residence, attempted to pull his father off of his mother, and the defendant retaliated against his son. His son's name is Rashid Jones, Rasheed. He retaliated against Rashid by hitting Rashid in the head with a vase. The officer did observe injury to the son, a laceration to the son's head that was consistent with him being hit in the head with a vase by his father. And so both of these incidents happened around basically at the same time. And so as the state did note previously with regard to the history, the defendant does have prior convictions for committing battery against this same exact victim. They're not married. However, it's the state's understanding that they have been boyfriend and girlfriend for over 20 years and that they live together. We have had contact with the victim. She does indicate that they do share that one son, Rashid Jones. And she stated that she doesn't fear the defendant, but she does not want him to return to the residence. She stated that this has happened before and that he has been arrested for violence against her before. So she also asked for a one-time law enforcement escort for him to retrieve his belongings from the residence. So for those reasons, Your Honor, the state recommends a $6,000 surety bond $3,000 surety on each count of battery family violence, the one count involving his son, the other count involving his girlfriend. The state is also recommending no further contact with either of the victims. That is Rashid Jones and Viola Goodman. The state is also recommending anger management as well as a stay away from the incident location, which is 3255 Harris Drive in College Park. Nothing further.
My calendar only has one battery family violence on it for the case number ended in 895F. Is there another number that needs to be considered here, or Ms. Campbell? Do you have both of these cases? Bridgewater, did you hear me?
I'm sorry, what, I just show one.
Right, I want to make sure that if there are two, and I'm being told that there are two, that we make sure that we have the proper paperwork for both those, so.
So it looks like, and good afternoon, Your Honor, my name's Anna Allen. I'm stepping in for Ms. Falk as the supervisor, but it looks like maybe there was one charge or one warrant, and we added a charge and filed an accusation for 2 batteries. Is that what happened in this one?
That is correct. The officer took out one warrant. He listed 2 victims in one charge. But when the Solicitor General's office noticed that, we did break the one charge down into 2 charges so that it could be separate, 2 separate victims. But both accusations were filed with the clerk's office this morning, one for each victim. So I'm not sure why they're not showing, but they were both filed with the clerk's office.
So you're telling me that we should have 2 battery family violence cases?
No.
2 charges? I mean, 2 charges?
Yes, ma'am.
Under the same case number?
Yes, ma'am.
Okay. All right. I'll add it because it's not listed that way.
Okay.
I wanted to make sure. Thank you, Ms. Helen Allen.
Of course.
Anything
And if
further?
we need to circle back at the end of the calendar and make sure everybody has what they need, we'll absolutely do that.
Okay.
Not a
very
problem.
good. Thank you. Ms. Kim?
Yes, Your Honor. Mr. Ronald Jones is 71 years old, and Miss Viola Goodman and Jones, they have been living together for 27 years. Of course, they have a son, Rashid Jones, who is 24 years, and there are 4 other stepchildren that he has. He has been here in Georgia all his life. He's native Georgian. He works at Piggly Wiggly for the last 5 years. He also owns a landscape business. So from after this hearing is over, he's not qualified for public defender's service. So I just wanted to make an announcement for that. And he graduated from high school, and he does need some prescribed medicines at the jail because of his health condition right now, medical condition. He does have some attention he needs, and we would like to request for a signature on bond. And yet, because
I'm so sorry. We're trying to work it out. I apologize.
Okay, thank you. Go ahead, Ms. Kim.
yes, the earliest one was 2011, so there has been more than 11 years, and this is kind of like incident that happened. We would like to request for a signature bond for this. If Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 good bond for both charges, totaling $2,000 good bond. Thanks.
All right, so for each charge, it's going to be a $1,500 good bond, which makes for a total of a $3,000 good bond. No further contact with Ms. Goodman or Mr. Jones. Stay away from the Harris Drive address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond.
Thank you.
Good luck to you, Mr. Jones.
You said 3,000 good bond, correct, Judge?
Yes, 15 per charge.
Position 5, DeBerry.
Good afternoon, Mr. DeBerry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor, good afternoon.
Good afternoon. Thank you, sir. You have been charged in case 22 CR 007885B with simple battery family violence. Is there a history, Mr. Howard?
His ninth arrest, last was 2015, hit and run DUI. I pled NOLO to the hit and run. 2010, felony terroristic threats arrest. 2010, stalking disorderly conduct, 2 counts conviction. 2005, probation violation, 04 suspended license. That's pretty much it.
Okay, Backus.
I do see that he is wanted out of Adele, Georgia for a probation violation. I'm not sure. I don't know if Mr. Howard knows what that's for, but that is there as well. In addition to the history, this incident occurred on the 19th. An officer was dispatched to 3810 Will Lee Road in reference to a trouble call. Upon arrival, the officer spoke with LaToya Daniels, who said that her and her boyfriend of years had decided to move in together and that they do live together at that incident location. She said they had an altercation and that the defendant stormed at her while she was in the kitchen and slapped her. The argument was apparently over a Wi-Fi connection. The son of Miss Daniels was present when this occurred and did see the defendant slap his mom while she was in the kitchen. The state is requesting a $2,000 surety bond. No further contact with Ms. Daniels. Stay away from that incident location. 1 day anger awareness, no alcohol, drugs, or weapons. And I would assume that if Your Honor grants the stay away, he would probably need a one-time police escort. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Andrew DeBerry is 42 years old. He has been in the Atlanta, Georgia area his entire life. He completed high school and also is a commercial truck driver. He also is employed at the city of Atlanta as a wastewater operator. He has been in that position for the past 2 years. He strongly denies the allegations, Your Honor. We do not have any recent convictions for violence. The defense is unaware of any warrants on Mr. DeBerry. I'm requesting a signature bond, Your Honor. According to the report that I received, he is recommended. I am requesting no violent contact. Mr. DeBerry wants to have contact. I did have the occasion to speak to Ms. Daniels. She wants to have contact as well. And further, Your Honor, that is his residence. Thank you, Your Honor.
Your Honor, the state would be opposed to, it literally happened 2 days ago. There hasn't been a sufficient cool down period for him to go back into the home. And it would be not right to misplace Ms. Daniels. And so the state would ask for that stay away. Nothing further.
Thank you. Ms. Daniels, I see you there. If you would like to address the court, I'll need to for you to unmute yourself and raise your right hand for me. The other one. Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, I'm not sure if I can hear you, Ms. Daniels.
Yes.
Okay, you can put your hand down. Thank you. What would you like to tell the court?
I'm not afraid of him. I rather him be home, taking care of home. Like, we always have been together for 8 years. He's never put his hands on me and done anything like this. And I don't want to take away his, freedom or anything from him so we can move better. And the decisions that we make upon here and now, we'll do it as an adult and nothing violent is going to happen.
Okay, has this occurred before?
No, sir.
Are you afraid of him?
No, sir.
Okay. All right. Thank you, ma'am. Anything further from counsel?
Nothing from the defense, Your Honor.
All right. If not, it's going to be a $3,000 signature bond through pretrial. I don't have that he's recommended. If he's not recommended, it's going to be per the judge. 1 day anger awareness. No further violent contact with Ms. Daniels, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. DeBerry. You also, Ms. Daniels.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Position 1, Chavez.
Good afternoon, Mr. Chavez Parada. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 0078887H with driving under the influence of alcohol less safe and suspended registration. Is there a history, Mr. Howard?
His ninth arrest. Last was back in February, probation. He is on probation for robbery and possession of marijuana. It's 15 SC 136972. 2016, they gave him 9 years probation. Got a 2018 misdemeanor possession of marijuana. It was reduced to disorderly conduct, time served. Got another driving without a valid license, misdemeanor possession of marijuana from 2015. Also has history out of Florida. See a 2018 failure to appear. It's for possession of a controlled substance. 2022 probation out of Florida as well. 2018 misdemeanor possession of marijuana. And a 2016 marijuana possession. Possession of a controlled substance without a prescription. Drug equipment. That's it.
Yes. You're on mute.
I see. My apologies. This incident occurred yesterday. An officer initiated a traffic stop due to the vehicle's registration showing as having been suspended. The officer had responded to the parking lot of 10305 Medlock Bridge. That's the Bliss Bar and Lounge, about 10 minutes prior to the stop. So during the prior interaction, the defendant appeared to be under the influence of alcohol. Because of this, the officer told him not to drive and to seek other means of transportation. He stated he understood the instructions, got in the car, drove anyways. The officer then ran the registration. It was suspended, so that's when he did the stop on Medlock Bridge Road, where the officer made contact with the defendant and verified that obviously it was the same person he had spoken with at Bliss. And as he opened the driver's window, a strong odor of alcoholic beverage came from inside the car. The officer noted his eyes were bloodshot, his speech was slurred, and so the officer asked if he would take the standard field sobriety test, which he agreed. The officer did observe a significant number of impairment clues during the test. And the defendant then told the officer subsequently that he had had a vodka mixed drink prior to driving. Your Honor, based on the drug and alcohol history, again, he does have that 2016 drug charge where he received 3 years probation. He's already on the open probation. He's got a 2016 furnishing alcohol to minors, and he's got 2022 probation violation out of Florida and a 2022 probation violation out of Georgia. And so because of that, the state is asking for a $5,500 surety bond, $5,000 on the DUI, $500 on the expired tag, DUI court, and no alcohol, drugs, or weapons while out on bond. Nothing further.
Yes, Cam.
Thank you, Your Honor. Mr. Jesse Chavez Parada is 24 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here. Mr. Chavez Parada completed high school. He is currently employed at Instacart. He has been in that position for the past 3 years. He strongly denies the allegations, Your Honor. I'm requesting a signature bond on Mr. Chavez Parada's behalf. If Your Honor determines that he is ineligible, then I would ask for a more reasonable bond, total of no more than $1,250. That is $1,000 for the DUI and $250 for the expired license. According to the history that I heard, this is his first and lifetime DUI. Therefore, we are opposed to any DUI court recommendations, Your Honor. Thank you.
Okay, for the DUI, it's going to be $1,750 good bond. For the suspended registration, a $250 good bond, making it a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Chavez Parada.
Thank you, Your Honor. I appreciate that.
Thank you, Your Honor.
For position 2, it's gonna be a medical reset, Judge.
So we're gonna reset him until tomorrow, 11/22. Okay, is that complete us this?
Yes, we're completed in court.
Okay,
Thank you.
I'll see y'all tomorrow then. Thank you.
All right, have a good one. Thanks.
Do the same. All right, Ms. Bridges, you are
You
up.
ready for me to take it, Judge? Okay, once again, everybody, the reset date for the SAP calendar is going to be December the 13th. Position number 1 is reset SAP with a $2,000 total good bond. Position number 2 is a medical reset till tomorrow. Position 3 is reset SAP with a $2,000 total good bond. Position 4, reset SAP with a $15,000 good bond. Position 5 is reset further notice with a $3,000 SOB through pretrial. Position 6 is going to the SAP calendar with a $2,000 total good bond. Position 7, SAP calendar with a $2,000 good bond. Position 8, reset further notice with a $5,000 SOB through pretrial, and that's the total bond. Position 9, reset further notice with a $3,000 SOB through pretrial. Position 10 is going to the SAP calendar with a $3,000 total good bond. Position 11, reset further notice with a $2,000 SOB through pretrial. Position 12, reset further notice with a $3,000 total SOB through pretrial. Position 13, reset further notice with a $2,000 SOB through pretrial. Position 14, reset further notice with a $3,000 total SOB through the jail. Position 15, reset further notice with a $2,000 SOB through the jail. Position 16, reset to the SAP calendar with a $500 good bond. And position 17, reset to the SAP calendar with a $1,500 good bond. Are there any questions, comments, or otherwise?
What was number 1 and 7?
Number 1 is going to the SAP calendar with the $2,000 total good bond.
And I really hate to ask you this because you said it clear as day, but
It's
what was the reset date again?
SAP 1213.
Thank you so much.
You're welcome. Are there any others?
I need number 7 as well.
Number 7,
Yes.
coming up. Number 7 is reset to the SAP calendar with a $2,000 good bond.
Thank you.
Next, anybody else?
I'm out of
Okay,
here.
that's good.
See you tomorrow, Judge.
All right, we'll see y'all tomorrow. Have a good evening.
Bye-bye.
All right, everybody, take care.